going to use State v. Martin because that's the one PT everybody in the class did. And I copy and pasted on 3 separate documents, just like you'll have in your Meazure software of the task. So you can see the whole task here, okay? Everyone sees that clearly? Yes? Okay, cool. And then you can see I have the full case law as well. So both cases, there were 2 cases on this performance test. This is July 2019, to remind you. And then I have a blank document for the answer. That's my answer document. And I also have, of course, somewhere in here, the facts. Okay, so I have the task, the case law, and then the facts. I'm looking for the facts. They're here somewhere. Here they are. Okay. So all the facts are here as well. So I've copied the facts onto a separate document as well. Okay, so 4 documents: blank, task, file, library. And what you're going to do is you're going to start, of course, you're going to still briefly read those instructions really quickly, okay? And then you're going to go right to your task. So we're not going to do this whole performance test, but I'm going to show you methodology and timing first and foremost. So as a reminder, this was an objective memorandum. There is an evidence as your subject, and there were 3 incidents, okay? There were 3 incidents that occurred, and you had to take the incidents and determine whether the evidence, each incident of evidence can come in on either substantive grounds or impeachment grounds, right? That was your task. So always in a PT, you have a little bit of background in the beginning paragraph, and then you have your actual task. So what I want you to do with the task, and right here is the paragraph of the task. Well, these 2 paragraphs, excuse me. It says, we want you to use all 3 of these incidents as similar acts evidence to rebut the defense that we expect Ms. Martin to offer. I would like to admit them as substantive under Columbia Rule of Evidence 404. And then I would also like to use them to impeach if she takes the stand under Columbia Rule of Evidence 608. Now, right away, you're thinking, I probably have a case, right, that's going to identify the standard of both 404 and 608. So what I want you to do is copy the task, the relevant task. Now, remember, you also get your tone from the task, okay? So I'm going to be doing some refresher teaching today. So you get your tone from here. It says objective, right? Objective appraisal. So you copy it. You go to your blank document. Oh, I need to get this all organized better. Come up wherever you are. Okay. So you go to your blank document and you paste the task. That's what I want you to do, the relevant part of the task, not the entire thing. Now, make some space, and because this is an objective memo, we're going to set it up right away after you paste the task. So we're going to have a from applicant, don't put your name, a to, and then go back to the task quickly. And we have Andrew Salmark, the assistant district attorney who we're responding to. Oh, it's hard to toggle, but I know on the exam you'll have the tab, so that should be easier. And then date, whatever date it is. And then regarding State v. Martin. Okay, so set that up right away as your objective or even your persuasive memo, and you have the task here. So right away, you have 2 parts to your PT answer, a substantive evidence section and an impeachment section, right? There's 2 parts. Now, you're going to eventually delete this, right? Now, you're going to make a little intro, just give a summation of what your task is to Andrew, all right? But just keep in mind, you will delete this. Why I'm having you copy from the task is so that you never need to go back to the task document again. Now it's in your answer, all right? So this definitely, every methodology that I'm teaching today should be tried out in a sample performance test. You can redo one that you've already done. I think that would be the best way to do it. Don't do a new one, just do one you've already done. Okay, so then you're going to go to the facts. Now, I know typically I've had you spend some time on the facts, getting a gist. Now, pursuant to this PT, in the task memorandum, they don't give you the names of the incidents, right? They don't give you them. So that's the first thing you need from the facts. So you're going here and you're not going to spend a lot of time on the file anymore. So typically I had you doing like 15 minutes. I want you to do just like a cursory review of what you have and anything you need pursuant to the task, okay? So here in this performance test, I need to know, what are my 3 incidents? What are these items of evidence that they're having me evaluate in an objective manner to determine if they can come in on substantive or impeachment grounds? So I'm going through here. It looks like this is just testimony, and I'm looking for any names of incidents. And I am going to speed through this a little quicker, right? And not actually take my time because I know this PT quite well. And I see right here, I am referring to 3 separate incidents. And we have good faith belief, blah, 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 broken tail light. So we had identified that as a traffic stop, right? And how you name these doesn't really matter. But my point is, I don't want you spending an abundance of time on the facts anymore with this new format, because we're going to go back to the facts later. But right now, we don't have, a lot of scratch paper. We don't have scratch paper. We don't have anything that we can, reference. So we just want to get the gist. So I have 3 separate incidents. One is the traffic stop. Then it says, second, we have a good faith belief that another officer stopped Miss Martin on the sidewalk outside the blue bar, and she was visibly intoxicated, right? So that's the second incident, public intoxication. And then third, we have an incident regarding a conversation with a Bernicia Martinez, okay? So what are you going to do on the exam if you're like, I can't remember the names of each one, and then go to my my answer document, right? You can copy this whole thing, write out the names of the incidents, or you can go one by one, okay? Does that make sense? So you can go, okay, I need to identify first that I have a traffic stop. I mean, let's just see how it would work if you copy and pasted. Copy this part of, excuse me, I still have this horrible cough. Copy and paste that here. And now we can do some organization pursuant to the task, a little bit, right? So I have 3 incidents. I'm going to summarize. Traffic stop. And the third one being conversation with. Okay. So after I have that, I delete this out. See that? Okay. Now I have the 3 incidents. So that's a way that you can maneuver that. Now you may not need to copy and paste anything from the facts at this point. Every PT is different, right? So this particular performance test, you needed to know the names of the 3 incidents, so that was relevant. Now you're going to go literally right to the case law. So I want you to get to the case law quicker. So let's put some timestamps on this, okay? Copy and paste from the task to your blank document, no more than 6 to 8 minutes. 6 to 8 minutes, copy and paste from the task to your blank document. Perusing and skimming the file, copying anything necessary there, no more than 10 minutes. So now we're at 16 minutes. Now remember, your preliminary outline time should take 40 to 43 minutes approximately, right? 45 max. Really want you to leave yourself at least 50. I mean, in this instance, really get out of the file quickly is my point. I don't want you spending too much time on the file anymore. We got to get to the outlining of the case law, because the objective is, at the very least, if you can get your case law organized in IRAC fashion, even if the analysis is not going to be, blow you out of the water amazing, you'll still get a 65 on your performance test by finishing it, okay? And having all your case law properly briefed. So I want you to get to the case law quicker, and really spend time copying and pasting and organizing. And I'm going to show you how to do that in a moment. Okay. Any questions so far? By raise of hand? Okay. Now I know in the middle of memorization to have this new approach is not, modified. I'm trying to make it as simplistic as possible and still in line with the flow of what we've done. But you can do this. We have a couple weeks to still get this flow down with some practice. You definitely can still get this down, okay? And you already know the maneuvering for the most part. So now we go to the case law. Now I'm going to remind myself before the case law of the task again. 3 incidents, 2 items to get them in. Substantive or impeachment, okay? So where's the case that's going to give me the substantive standard? And in the case law, which likes to hide here, okay, I have 2 cases. So as you all know, we go to the case and we see where's the law. Here on this page, I see 404B. Okay, that's the statute they gave me, the rule, the code. I'm looking for law, and now I went ahead and I already highlighted, okay? I think it is a good rule of thumb. You will have a highlight feature. I know it didn't work during the mock for a lot of applicants. I don't know any that it worked for. I hope it works in the exam, okay? We're going to stay positive. Hopefully it'll work in the exam. I'm confident that they'll get it together. Okay, so as you remember, they gave you this really nice laid out test. And it was a 2-parter, and it says, to determine whether preferred evidence has relevance for one of the other purpose, the court considers the degree of similarity to the charged crime and the temporal relationship of the other acts. Is this your intro to the law on the substantive issue? Yes, so you copy it right away, your 2-part test. You go to your blank document. Where did everyone go? There we go. You go to your blank document and you go up here. I put the task way up there. You make introduction and you literally copy that. Boom. What a time saver, okay? So there is a beauty in the copy and paste, right? You don't have to type all that. And that's literally your intro. In determining the admissibility, the wording of the case law is really straightforward here. And it tells you the full introduction. And then you know right away you have the traffic stop as your first incident. Now I would even do a heading here. Admissibility on, everyone can see the screen well? Yes? Okay, thanks. On substantive grounds. So you're already framing your answer. You have your intro, and then you have, boom, the traffic stop. And you have a 2-part test. So, degree of similarity, remember RAC. Now, you don't have to do RAC. First of all, you don't know if the case law is going to give you a rule for this, right? You don't know at this point. You're just briefing just the intro. But maybe they do. If not, you'll just delete the R, right? And you analyze pursuant to what? The facts of the case, right? Or your facts on point. But I would put it there as like a benchmark, just in case they do give you a rule. A lot of you at times do miss your rules on your IRACing for case law. So let's put it there just to be sure. We're going to go back to the case and say, is there a rule for a degree of similarity here? Have they given a rule? Okay, so let's put the RAC. Don't forget to conclude. That's important. And then what's the second part? Temporal relationship. I want to show you something here. RAC. Are you going to have to, I mean, obviously a lot of you know this already, but are you going to have to identify the degree of similarity and then temporal relationship for all 3 incidents? Yes. So what you're going to do here is you're literally going to copy that part and you're going to go into every incident and you're going to paste it. See that? Because you have to identify it for each one. So the copy and paste feature, if you really practice this, can be a very big time saver. Okay, a very big time saver. All right, so now we have the two-part test for every item, for every incident, and you can label them. I'm not a huge big into a lot of labeling on the PT, but in this instance we have 3 incidents, so I think it would be good to be organized here. Okay, any questions on that methodology so far? So notice, because I knew that I had to identify this test. Now, not every PT is going to be like this, right? But in this scenario, it works really clean, right? Where I have 3 incidents and a 2-part test for each one. I basically set up the majority of my answer for the substantive evidence. Now, I don't know the rules yet. I'm not sure if they're giving me any law for any parts of these, for the temporal relationship or the degree of similarity yet, but I have a big template set up, right? Structure wise. Okay. Is this helpful so far? Yes. Okay, cool. Gosh, I've been racking my brain literally at night, like not sleeping. Like, how am I going to configure this? I mean, it doesn't seem that complex, but it has to be really organized. That's the key, because you're in a time crunch. Okay. So you're basically setting up your answer and outlining the full answer as you're briefing the case law now. Okay. It's not just briefing case law, it's literally structuring it. So I do think really important to put these RAC to say, okay, go back to the case now and say, go start from the beginning. Do I have a rule for degree of similarity? Do I have a rule in the case? Either case can give it to you, by the way. Someone asked me, do they always go in order? Not always, okay? So you could go to case 2, and case 2 could have the rule for temporal relationship. That didn't happen here. They gave you all the law for the substantive basis in the first case, and then the Proctor case gave you all the law for impeachment grounds. So here it was sequential, but it's not always going to be like that. All right. Any questions so far? Shelby.
So after you get through the one of the incidents, can you do an overall conclusion on like the admissibility on substantive grounds for each one?
Yes. So that's your C. Good question. That's your C right here, right? So you have your conclusion for every element. And then at the end, you're right, there should be another conclusion as to the totality of the item, right? Because when you look at this, that's such a good question. Thank you for asking that. When you look at the 2-part test, there's the word and, right? So each part of the test has to be met. So you do need an overall conclusion here as to the traffic stop, as to public intoxication, and then the conversation. Okay. All right. So now let's go back to the case law. And I'm looking to see, is there any law regarding the the degree of similarity and then temporal relationship? There was this little blurb here. It wasn't very straightforward in this performance test regarding the law. It was kind of like mixed into facts, but there was some law regarding the time. So prior acts are also sufficiently close in time to the charges in this case to satisfy our prior decisions. Acts of violence or intoxication are not sufficiently similar to the crime of passing bad checks to permit any interference. So this rule right here is going to be relevant for the public intoxication issue only, right? So I see that right away. I'm going to copy it, go quickly back here and go to here, degree of similarity, and paste that. Okay. Everyone saw what I just did and why I did that? Okay, cool. And gonna go back here. And I'm going back up here. It says specific acts can be the basis for inferring that the defendant had a mental state that is inconsistent with innocence. Our prior cases have often established that similar acts may be admitted to rebut a claim of innocent involvement. It says affirming the admission of evidence of prior importation of drugs. So that's kind of in regards, I think the actual rules a little bit above here. Here, 404B1 prohibits the admission of prior bad acts to establish an individual's character or propensity to commit a crime. However, the admission of prior bad acts for other purposes, such as proof of motive, opportunity, I still don't see degree of similarity. Let's see here. Law and objected to both, arguing they constitute specific instances of conduct offered to prove a person's character in order to show that on a particular occasion, the person acted in accordance with the character. So that sounds in line with a degree of similarity. And there was, right over here, this was really the crux right here. The prior mortgage application is also sufficiently similar to be relevant. So here you would have to say something like the mortgage application in your rule. The other bad act need not be identical to the crime charged so long as it is sufficiently similar to permit a reasonable inference of knowledge or intent. That's your rule. That's your rule right there. For substantial similarity or degree of similarity, excuse me. And I'm not going to fully brief it for purposes of today because this is just like an example, okay, to give you an idea. But obviously, in your approach to case law briefing, anything relevant for a rule section should be in the rule section, okay? So copy and paste, use a transition word in addition, also, and then you can add as much law as possible. And there's no such thing as adding too much law, okay? There's no such thing. Copy and paste as much as possible. All right, so that gives you an idea of the cut and paste, right? From the case law to the answer. I'm not going to do the whole performance test, but then you'll go through each one. Now, keep in mind this rule right here, because it's the only rule they're giving you for the degree of similarity for the traffic stop. You're analyzing and concluding. And then also for, you had a separate rule for degree of similarity for public intoxication. There was no separate rule regarding this conversation with Bernicia. So you're going to delete the R here. I'm just giving you the heads up, right? And you're just going to analyze and conclude. Okay. Joe, I saw a hand.
When we copy and paste, can we do we have to worry at all about word for word copying and pasting
Not at
or
all.
just
I
cite?
don't want you to summarize it. The facts, yes. But when it comes to the law, literally verbatim. Now, that's assuming they give you a really clear rule. What if the rule has some facts in it, right? And it's not like the holding is, and you have to say similar to the holding or the factual scenario in Proctor, right? That used the middle approach for impeachment, which is what ended up happening in that case. Our client also has a similar situation, right? So you may have to do some modification of the rule if they're not giving you a clear black letter rule, okay?
Yeah.
They're not giving you a real holding. For the most part, you should have very clear holdings and rules.
Cool. Thank you.
Of course. Okay. So now assume, let's just say for purposes of this example, we're done briefing all the case law, okay? Pretend we're done briefing it. We've copy and pasted. Now notice I have not analyzed at all, okay? So there's been absolutely no analysis. What do you do now? So let's just say in terms of time. So we have about 16 minutes. That's maxing out by the time. That's way too much time. Let's try and get to the case law briefing within 12 minutes from the start of the PT. 12 to 15 minutes max. Copy and paste the task. Go into the facts and bring out whatever you need for just the task structure and get right to the case law. So really what you're doing is you're writing your performance test and from the moment you start outlining the case law, right? So there's no more like you're going to outline the law, but then you're going to go right in, you have the structure and plug in your A and C, okay? So let's make sure for sure that we're adding RAC under each heading, RAC. If you don't have a rule, delete the R, but you still have the heading AC. Now, also keep in mind, if we're in a persuasive PT, keep your headings very brief But when you conclude, do a regurgitation of your conclusion and make sure your heading is persuasive. I talked about that in the workshop, but just to make a refresher, okay? Some of you did kind of have some issues with some persuasive headings. I know the graders were really anal about that. It is important to have the proper tone. There's a lot of points, up to 20 points associated with proper tone. So where you find the tone the most is what? In your heading and your conclusion. Heading and conclusion, okay? So make sure that it's like persuasive heading should be a full sentence. Just regurgitate whatever conclusion you've made. All right, so now you're ready to analyze. I think this is going to be the trickiest part because you don't have the facts in front of you to mesh the rule and the analysis together. So you'll go one by one. You'll say, okay, acts of violence or intoxication are not sufficiently similar to the crime of passing bad checks to permit any interference of knowledge or intent. Make sure you have a period there. And now you're going to go into the facts, and you're going to look for relevant facts regarding the act of violence and what happened here. Okay. Police officer stopped Miss Martin for a broken taillight. So all this regarding incident 1, copy and put here. Okay, so this is all the facts regarding incident 1. Actually, I'm sorry. I'm gonna modify that. Put it, because you're gonna have to use it for temporal relationship as well. Wait, I'm in the wrong section. That's the traffic stop, right? That's the first one. I apologize. Okay, so we're in the traffic stop. All the facts regarding the traffic stop, I'm gonna put here. Keep it highlighted so that you know to delete it, okay? And then I'm going to look through the rest of the document. Is there anything else regarding the traffic stop? I don't see anything. No. Go back up. That's all the facts regarding the traffic stop. Everyone see that? So now I have the facts here. Where's my blank document? Why does it keep doing that? Okay. This is not my friend, this toggling thing. I don't like this very much. There it is. The answer. And I have all my facts here. So now I actually would even bring it down to a separate page. So it's all on the same page. And I can analyze pursuant to the facts now in front of me. Everyone see that? So you skim the case law, issue by issue for any facts related to that, in this case, incident. So if you were on that criminal procedure performance test with the non-routine search, you would copy and paste anything regarding in both documents, the search of the cabin, right? And what happened there. So anything in relation to each particular issue, the facts you copy under the heading, and now you can analyze degree of similarity here. You also might even go back to the case law. I mean, are you going to be able to do heavy compare and contrast in this format? No, you're not. I thought about it. And I don't think the standard can support it because, I mean, here's going to be the rule of thumb. You're going to analyze first just pursuant to the facts from the file. You're going to finish all your analysis by copying and pasting the relevant facts for each section, making your argument, and then deleting the facts. Everyone with me? Okay. And then if you have time left over, you'll go back to the case law and see if there's any compare and contrast that you can do on major issues, right? Issues that the case really goes into. But if it's between briefing your case law and making your analysis and concluding on each section, that is going to rule. That is your strategy. That is your focus. Because there is no way that the California State Bar can expect you to make major compare and contrast analytical posture without having the case law right in front of you to do that compare and contrast, right? Don't you all agree with me? I mean, I think that that is a very high burden, and I don't want you to have a lot of stress about that. You can come away with a 65 by finishing your PT and making sound arguments with the facts given. Okay. Now, if you get stuck on analysis, then you can go to the case law to see how are they arguing for this issue, right? How are they? And that might help you to copy their argument on the, maybe they give a really good argument regarding degree of similarity. You can copy the case law argument right under the heading degree of similarity, make your analysis similar, and then delete it. Okay? You can do that. So what I want you to, the goal is that anything in relation to each particular issue, you're copying under the heading for that issue, using it to make your analysis, and then deleting it out. Okay? Don't forget to delete it out. Any questions? I think Shelby had a hand up.
I guess I was just gonna say it makes sense to do impeachment also, write out impeachment and take the facts and just copy them down. So each incident and then do the like a RAC.
So let's do that. Let's do the impeachment section to show you. It's a little bit different because you don't have the two-part test, right? But the second task, 2, was admissibility on impeachment grounds, right? So what you'll do here is quickly copy the, you need the incidents. So we have traffic stop. We have no idea at this point what the standard is, right? No clue. So traffic stop, and we don't know if we have a 2-part test. So I'm not going to do RAC yet. Public intoxication. And then the third is the conversation with Bernicia Martinez. Okay, so now let's go to the case law here. And we have Proctor. So this is really all how these cases start out. A lot of just kind of back and forth. I'm looking for the rule 404B. Evidence of shoplifting. No, that's not a rule yet. As to the use of evidence, I'm looking for impeachment. What's the law on impeachment? If a witness takes the stand, that has my attention. Here I see about a child witness shoplifting. Okay, so obviously this case is kind of in line because we have shoplifting in our case as well, just to refresh your memory. If a witness takes the stand and testifies, she puts her credibility in issue. Under 608B, which is your task, right? 608, that's where you go, okay, what is 608? Okay. A witness may be asked about specific instances of conduct that are probative of a witness's character for truthfulness or untruthfulness. The rule does not explain how to determine if an act is probative of truthfulness. Boom, I'm copying that right away. Oh, I'm going to go here under impeachment. Paste. That's my rule, part of my rule. Okay. So if you're not deleting it, then leave it, take out the highlighting right away. Okay, that's another little thing. If you're gonna delete it, leave it highlighted when you copy it. So highlight it and then copy it and paste it highlighted, like the facts, so you remember to go back and delete them. And I go back to my case law. There was a little bit more law, if you remember. This whole thing is relevant because they talk about 3 different approaches and they apply the middle approach, right? Literally, boom, baya. Copying this whole thing. Listen, we have to see the silver lining here, okay? We can copy and paste. You don't have to copy a whole rule. The trickiest part is going to be the analysis, for sure, okay? But we're going to do it. We're going to copy the facts that are relevant for these areas, and we're going to make some analytical posture. But we're going to have organized, IRAC'd, very clear case law briefed performance tests and finished. You have to complete it, okay? So copying this, I'm going right to my answer, and I'm applying that. And I'm taking away the highlight. And this is not too, why do I keep doing that? This is not too much law, by the way. This is beautiful. I love this, okay? Like this is showing like the law here. This is the rule. And it took me not even 2 minutes to do. Okay. So I see this approach, the narrow approach, they're going back. And now one thing you do want to change. Okay. We are most persuaded. So when the court refers to themselves as we, obviously modify that to the court was. Okay. So don't, you can do some, now if you forget to do that and you leave the PT and you're like, oh my gosh, I left it in like, first person court, it's okay. All right. This is what they're giving you. We're going to work with what they're giving us. So we're going to do our best, but can't be perfect here. It's just a lot. Okay. The court. And it says the middle approach, which incorporates the narrow view, but would also permit questioning about conduct that indicates a willingness to gain a personal advantage by dishonest means. Okay. And then I'm taking out this part. So we have here the middle approach. Now, really, do you need this whole thing here? Yeah. This gives you a little summation of 608B, talks about the 3 approaches, and then says we want you to apply the middle approach. And then you're going to here give the middle approach rule. One time, short form, right? You don't have to repeat it again for every subsequent impeachment. And I believe in this one, there were some sub-impeachment issues for some of the other incidents. Okay, I'm not going to do the whole thing, but you have the idea here, right, of what I'm doing. And don't forget the overall conclusion under each one. I'll just write OC for now. Like the show, Laguna Beach, OC. It's from the OC. Okay, I don't know. All right, so that is your briefing of the case law, and then you go back to the facts, and you copy whatever now is in regards to the impeachment sections, and you go through and do it for each standard. Now, it's likely going to be in this case, a lot of the same facts that you copied for the preliminary part for the substantive evidence, right? And what they're going to testify to. They didn't give you a lot of facts. So what I would do is, if you have facts that are relevant for a beginning area of your PT, you delete them as you analyze them, okay? But if you go back into the facts for the second section or a third section, you just copy the facts again and paste them and analyze them for that section. Does that make sense? So don't leave them above, because I don't want you submitting performance test answers with facts copied just into your answer and just sitting there, okay? So I know this is a digression. How much time you're spending, I would say outlining the case law. If you stick to the, let's say, max 15 preliminary minutes on the task and the file, then you're looking at maybe 35 minutes outlining the case law, 35, 40 minutes max, and then about 40 minutes writing your analysis conclusions. Okay? And you want to regroup. So like when you're done briefing the case law, you regroup and you say, okay, how much time do I have left? And then you literally watch the clock and go, okay, I have, here you had, how many sections? A lot. You had 1, 2, 3, 6, 9 sections. So you're looking at, no more than maybe 4 minutes per section, 4.5 minutes per section of analysis and conclusion. The good thing is you have your rules there. Any questions? I know this is, we're not going to use the word challenging. It's annoying for sure. Okay, for sure. The toggling. But am I in line with how you see it in Meazure? Like, I know you're going to have tabs. It's going to be more organized than having, these windows. But this is pretty much how they're giving it to you, right? Yes, applicants? Like, back me up here. Okay, so I'm just making sure by what I've been told and what everyone's done. Okay, so that's an exercise that I think would be really helpful for everyone to implement with at least 2 to 3 performance tests, just to get really comfortable with copying and pasting. you can totally do it on PTs you've already done. So I actually think that would be the best. So if you've done IBI, if you did Price from the simulated, even the State v. Martin, either any one of them, it's good practice. You don't have to do a brand new one. All right. Any questions? Imelda.
Can you just go back to the timings one more time?
Yeah.
Like how? Okay.
So task, copy and paste into your answer, approximately 5 to 6 minutes. Skimming of the file for any relevant organizational things, really, that's all. I'm kind of just getting familiar with what you have. 8 minutes. Like if there's 2 documents, 4 to 5 minutes max on each one. So let's say no more than 15 minutes before you go into your case law. So I am cutting from the original approach of the time we spent on the file. Because you got to get to that case law. It's going to take you time to cut and paste and go back from each window, right? So I want you to get your law down as fast as possible. So outlining of the law from the case law to your answer, I would say no more than about 30, 35 minutes. And then the remainder of the time writing your analysis and conclusions. Now, what I do want you to do in your case law is I want you to keep anything that you're using highlighted. So don't take off the highlighting function in the case law, cut and paste. So when you copy it and when you copy it, and you should also highlight it in the case law. That signifies that you've used it, not in the facts. Because likely with facts, you have to use them for separate sections. So I don't want you thinking, oh, if I've highlighted the facts, that means I'm not going to use these anymore, because you might need to for different sections of your answer. But for the case law, I want you to keep it highlighted. And when you're done briefing that case, I want you to do a skim and say to yourself, have I used all the law here? Is there any more law to copy and paste for the section that I'm in? Okay.